Hi, everyone. My name is Lindsay Morris, and I'm the Director of Leadership and Engagement at the National Council of Jewish Women in our Washington, D.C. office. Thank you so much for joining today's webinar, Cases and a Controversy. Wonderful to have you here with us today. Before we begin, I want to note that this webinar will be recorded for educational use, but is not for press purposes and is off the record. Additionally, this is a 501c3 compliant nonpartisan webinar. So while NCJW does not take positions on political candidates or parties, we do take positions on judicial nominees. As you may know, Article 3 of the U.S. Constitution establishes that federal courts can adjudicate cases and controversies. What that really means is that a generalized complaint isn't enough for a lawsuit. Rather, there must be an actual dispute between real parties for a federal court to get involved. But over the past year, it feels like case or controversy has taken on a whole new meaning. The numerous issues surrounding Justice Brett Kavanaugh persist, but he continues to decide real cases on our nation's highest court. Today, NCJW's Judicial Nominations Campaign Manager, Caroline Ostro, will delve into a few of those cases on the topics of sexual orientation and gender identity, immigration, and abortion. She will also address why it's so important to fully investigate Justice Kavanaugh. We'll also leave plenty of time for questions and answers, so please submit your questions through the chat box in Zoom, and we can also unmute your lines at that time. Throughout today's webinar, I strongly encourage you to keep in mind that all of these Supreme Court cases come from lower court cases. The lower federal courts are district courts, which are at the trial level, and circuit courts at the appellate level. While the Supreme Court is, of course, vitally important and the last line of defense when it comes to our rights, most cases never make it there. In fact, in 2018, 88% of cases were ultimately decided at the district court level and 12% at the circuit court level. And yes, your math is right. So that means less than 0.1% of all federal cases made it all the way to the Supreme Court. So putting it another way, in 88% of cases, district court judges have the final say, and in 12% of cases, circuit court judges have the final say. Like Supreme Court justices, lower court judges are nominated by the president, confirmed by the Senate, and serve for life. Unfortunately, many, if not most, of the 150 some judges confirmed under this administration lack qualifications, diversity, and independence. So I urge you throughout the webinar to think about the massive impact that lower courts and the judges who sit on them have. And later, we'll talk about how to make your voice heard in the process. So without further ado, let's get started. I'll turn it over to Caroline.
Thanks, Lindsay. Can you hear me okay? Okay, great. So I'll dive right in with the first set of cases. It's great to see all of your faces today. The first set of cases is actually 3 cases combined. Bostock v. Clayton County and the Altitude Express v. Zarda are about employment discrimination based on sexual orientation, and Harris Funeral Homes v. EEOC is about employment discrimination based on gender identity. The law at the center of all of these cases is Title VII of the Civil Rights Act of 1964 that states that employment discrimination on the basis of sex is illegal. So over the past 50 years or so, federal courts have circled the issue of exactly who's protected under Title VII. Its protections have been extended in various cases to women, to men, and those who don't conform with gender stereotypes. Perhaps the most well-known case in this topic is a Supreme Court case from 1989 called Pricewaterhouse v. Pricewaterhouse v. Hopkins, in which an employee, Ann Hopkins, claimed that she was denied advancement because she wasn't stereotypically feminine. The Supreme Court ruled in her favor and found that it was unlawful based on Title VII's prohibition against employment discrimination based on sex to deny Hopkins advancement because she didn't conform to those traditionally feminine stereotypes. And the analysis that scholars undertake when looking at these types of cases is really straightforward. If the same person is desirable as an employee, if they are male, but not desirable if they are female, then that's discrimination based on sex and vice versa. So this term, the court is addressing a hugely important question, which, given that straightforward analysis I just explained, seems like a no-brainer. In short, does Title VII protect lesbian, gay, and transgender employees? The importance of these cases is even more magnified when you consider that less than half of all states bar discrimination based on sexual orientation and gender identity, which really seems crazy in 2019, but it is the case. All right, so in the Bostock and Zarda cases, 2 men were fired from their jobs for being gay. Zarda, who has since passed away actually, was a skydiving instructor, and Bostock was a county employee in Georgia who had always received great employee reviews. And when the county learned that he was gay, it falsely accused him of mismanaging public money and fired him. So Zarda's a case, Zarda, that's the skydiving instructor, his case was appealed to the Second Circuit Court of Appeals. And they said that the case could proceed. They said that Title VII does protect gay employees, period. Bostock, the Georgia case, was appealed to the 11th Circuit, and they held the exact opposite. They said, no case, Title VII doesn't protect gay people. Sorry, or not sorry. And now the Supreme Court is going to settle that split. And then the third case you likely heard about in the news, it's about Amy Stevens, who is a transgender woman who was fired from her job of 6 years as a funeral home director when she informed her boss, the owner of the funeral home, that she would live and dress as a woman. The owner of the funeral home said that doing so would not only violate the company's dress code, but that by permitting it, he would be, quote, violating God's commands. And the Sixth Circuit Court of Appeals found that to be unlawful discrimination based on sex. They said it includes gender identity and trans status. And the owner of the funeral home appealed to the Supreme Court. So on October 8th, just a month ago, the Supreme Court heard 2 hours of debate on this set of cases. They were all argued together. So I'll kind of walk you through how those arguments went and hopefully answer any questions you have about them during the Q&A. And they were really fascinating discussions, and I wish it were possible to know exactly which way the court is going to go, but of course it's not, although it was really especially interesting to hear Justice Neil Gorsuch's, to hear his comments, because his textualist tendencies seem to make him more sympathetic to those seeking the protections of Title VII. So this on the screen is a sketch of Stanford Law professor Pamela Karlan, who argued on behalf of Bostock and Zarda, the 2 gay men that were fired. She encouraged the justices to really focus on the text of Title VII, saying that it was intended to make sure that men were not disadvantaged relative to women and vice versa. Seems simple enough. This is Jeffrey Harris, who argued on behalf of Bostock's and Zarda's employers. He attempted to distinguish between sex and sexual orientation, which did not go over well with Justice Kagan, who reminded him that the test of whether to invoke Title VII is whether the same thing, in this case, the firing, would have happened if the employee was a different sex. So, for example, If the employee was a woman attracted to men, not a man attracted to men, she wouldn't have been fired. And again, interestingly, Justice Gorsuch seemed to agree with this point, and he pointed out that Title VII only requires sex to be a cause of the firing, in his view. Justice Gorsuch mentioned this again later when this gentleman, who is U.S. Solicitor General Null Francisco, argued on behalf of the federal government as a friend of the court, supporting the employers. So yes, that means the Trump administration is supporting these discriminatory employers in court. So that's fun. And Gorsuch pointed out to Francisco that at least one contributing cause of these firings does appear to be sex. And then this is David Cole, who argued on behalf of Amy Stevens, the transgender funeral home director. And he presented that same straightforward argument we've talked about. That is, if Stevens had been assigned the female sex at birth, she wouldn't have been fired for wanting to come to work dressed as a woman. And here, Justice Gorsuch jumped in again. He asked Cole whether the justices should consider, quote, the massive social upheaval, end quote, that would follow a ruling in favor of Stevens. And you can roll your eyes here, I did. Cole rejected this premise and reminded Justice Gorsuch that courts have been recognizing claims like this for at least 20 years. And then Justice Alito asked Cole whether forbidding a trans woman to compete on a women's college sports team is a violation of Title IX, which is the federal civil rights law governing education. And Cole, more eloquently than this, basically said that the case had nothing to do with that. And this is John Birch, who argued on behalf of the funeral home. And he said that if Stevens prevailed, an overnight shelter for women would have to hire a transgender woman, even if survivors of rape or domestic violence stayed at the shelter. So here, Justice Breyer jumped in and dismissed the, quote, parade of horribles, unquote, that he said that was beyond the scope of this case. So it is clear that the justices will have a lot to discuss before issuing an opinion, and we expect that to happen sometime between now and June 2020. Of course, NCJW as an organization believes that a person's gender identity or sexual orientation should never affect their employment status or economic security. And we support the right of all people to live free from discrimination. So we will keep you posted on how this case unfolds. And the next set of cases we're going to talk about is those concerning DACA, or Deferred Action for Childhood Arrivals Policy. So this is a policy, as many of you probably know, announced by President Obama in 2012. It allowed undocumented immigrants brought to the U.S. as minors to apply for protection from deportation and for permission to work in the U.S., among other benefits. In September of 2017, then Attorney General Jeff Sessions announced that the administration would be ending DACA. Doing so would make many of the over 700,000 young adults qualified for DACA eligible for deportation. Attorney General Sessions made the announcement about ending DACA at a press conference where he called DACA recipients illegal aliens. Shortly thereafter, more than 10 cases challenging the decision were filed in federal district courts. There were cases in California, Maryland, New York, DC, and due to 3 specific orders issued by lower federal courts, those who already had DACA can thankfully keep and renew as of now, but no new applications are being accepted. Oral argument is this coming Tuesday, November 12th, and about a week ago, the Supreme Court announced that they would be extending the time for oral argument from 1 hour to 80 minutes. So we're expecting a really substantive argument on whether the decision to end DACA is even subject to review. That's the first hurdle. And if it is, whether that decision was legal or not. And as with those Title VII cases, we're expecting a decision before June of 2020. So in order to explain what we're expecting from oral argument, I'm going to do a really quick and basic administrative law lesson. We'll keep it really simple though. So the basic summary is that under the Administrative Procedures Act, which is a federal law, a federal judge can review decisions made by agencies if those decisions are, quote, arbitrary and capricious. However, there's an exception to this. If a decision is committed to the absolute discretion of the agency, then a judge can't review it. So the Trump administration says that that's the case here, that the decision to end DACA is not subject to a court's review because that decision was under the absolute discretion of the Department of Homeland Security. So in other words, a federal court, even the Supreme Court, doesn't even have the authority to hear this case. And then they say, oh, by the way, the decision to end DACA was legal anyway, because the Department of Homeland Security said that it's an illegal program. And that's that. There's not a ton there. And then the respondents, those defending DACA, they are going to argue that the decision to end the program is within a court's purview and not part of that exception for something that's within an agency's discretion. And they say to the Trump administration, hey, the reason you gave for ending DACA is that you legally had to. That's not the same thing as agency discretion. Plus, huge decisions like this with far-reaching consequences are not the type traditionally committed to agency discretion, so the court can hear the case. And in terms of the legality of ending DACA, respondents say the decision to do so was, quote, arbitrary and capricious, meaning that it wasn't made with reasoned decision-making. First, the Department of Homeland Security didn't explain why it claimed that DACA was illegal to begin with. They just said it was illegal. Second, the executive branch has broad authority to set and maintain policies. So DHS's claim that the Trump administration lacked the authority to maintain DACA is just incorrect. And lastly, DACA is part of a long tradition of discretionary relief for certain people. In this case, a carefully defined class of young people. And those are the many reasons why the decision to end DACA was unlawful. So I'm sure, as you all know, NCJW supports DACA, and we joined an amicus brief supporting Dreamers, those protected under DACA. And we will be watching closely on Tuesday to see how oral arguments go. And if you want to follow along at home, the hashtag that's being used for this case is #HomeIsHere. That's hashtag #HomeIsHere. So if you search that on Twitter, you should definitely be seeing updates on how the case is going. And again, that's this coming Tuesday morning, the 12th. And then the last case we're going to talk about before we shift talking about Justice Kavanaugh is June Medical Services versus Gee. A little over a month ago, the Supreme Court announced that it would hear this case, and it's going to be the first big abortion case since Kavanaugh joined the court. And the case is about a TRAP law. For those of you who don't know, TRAP stands for Targeted Regulation of Abortion Providers. And these are laws that are designed to close abortion clinics and make abortion inaccessible by imposing requirements that maybe sound like they're in the realm of reasonable, but actually have nothing to do with health or safety. Reasons provided for TRAP laws are disguised as medical, but in reality, they are purely political. Just 3 years ago, the Supreme Court struck down a TRAP law in Whole Women's Health v. Hellerstedt. This was a law from Texas that required abortion providers to have hospital admitting privileges within 30 miles of where the abortion clinic. The case was decided 5-3, and Justice Breyer wrote the opinion for the majority. He wrote, When directly asked at oral argument whether Texas knew of a single instance in which the new requirement would have helped even one woman obtain better treatment, Texas admitted that there was no evidence on the record of such a case. And that's true. Abortion is one of the safest outpatient medical procedures. The risk of complication is actually lower than that from a colonoscopy or wisdom teeth removal, which don't require admitting privileges. So why pass a law like this? As I said, to try to legislate abortion out of existence. When abortion providers can't meet this unnecessary and totally unrealistic standard, they are legally prevented from providing abortion services. And as we know, the right to abortion is meaningless without access to it. And that brings us to June Medical Services versus Gee. In short, the law at issue here is identical to the law that was struck down in Whole Women's Health. The only difference is that it's Louisiana instead of Texas. It's another 30-mile admitting privileges requirement intended to harm patients by shutting down clinics. Oral arguments aren't officially on the books yet, but those involved in the case tell us that they will be very late February 2020. And if you're thinking to yourself, why would the Supreme Court accept this case when it just decided Whole Women's Health? Then you're on the right track. The integrity of the Supreme Court hinges on its adherence to its own precedent, meaning that it can't haphazardly decide two cases differently if the same sets of laws and facts are presented. In fact, since this case was decided just 3 years ago, the court should have considered it an open and shut case and not even agreed to hear it. But unfortunately, in agreeing to hear the case, the court is signaling its own disregard for abortion precedent, and maybe even scarier, signaling that they're allowing lower courts to probably do the same. And we know this because the two cases are identical. The only thing that's changed is the makeup of the Supreme Court. So I'll let you look for a second to spot the differences between these two pictures. And now I'll tell you. This is 2016 on the left, and there's Justice Scalia and Justice Kennedy in all their glory. And here on the right, it includes Justice Gorsuch and Justice Kavanaugh, nominated by President Trump, who, as we all remember, promised to only appoint justices who would overturn Roe v. Wade. And here we are. So it's a very scary time. We'll be watching this case very closely, and we'll keep you all updated. And we encourage you to get involved. The hashtag in the case is #MyRightMyDecision. Again, that's hashtag #MyRightMyDecision. And NCJW has partnered on a website with lots of resources and ways to, make your voices heard in this case. And we will be sending out information for that in the follow-up email. And I do see that there are questions in the chat. Thanks, Jody. I will come back to those during Q&A. But thank you for those. So again, My Right, My Decision. Thank you, Lindsay, for putting it in the chat. And this is a perfect time to segue into talking about Justice Kavanaugh, and then again, we'll move on to questions. The bottom line is that there is so much we don't know about Justice Kavanaugh's personal and professional past. But what we do know suggests that there is a lot to be uncovered. So for example, Justice Kavanaugh worked in the White House for 5.5 years, from 2001 to 2006. However, after he was nominated to the Supreme Court, Senator Chuck Grassley, who was at the time chair of the Senate Judiciary Committee, only requested records from the National Archives related to Kavanaugh's service in the White House counsel's office for 2 years, 2001 to 2003. He didn't even request any of the records from when Kavanaugh served as staff secretary to President Bush from 03 to 06, despite the fact that, or possibly because this was Kavanaugh's most senior and significant position in the White House. Grassley's incomplete request shielded nearly 75% of relevant records from disclosure, and that's 3.85 million pages. And it gets even crazier. When the National Archives told Grassley that it would take months to fulfill even the request for 2 years of records, he refused to wait. And instead, he had President George W. Bush's political lawyer, Bill Birch, produce the records. So again, instead of a nonpartisan career professional at the National Archives, it's President Bush's political lawyer, who himself served as Justice Kavanaugh's deputy in the Bush White House. It's just a perfect storm. And he decided what to produce, what to redact, and what to withhold altogether. There isn't even a verified record of the scope of what has been hidden, but Birch admitted that he didn't provide over 200,000 pages because he claimed they were personal. For reference, 99% of Justice Elena Kagan's records from her time in the Clinton White House were released during her nomination. That included every email she ever wrote or ever received, as well as paper records. And they were sent from the National Archives to the US Senate and available to the public. And the reason these records are so important is because they show what kind of lawyer this person is, which seems like a pretty relevant assessment when you're deciding whether someone should sit on the Supreme Court of the United States. Based on what was going on in the United States at the time Kavanaugh worked in the White House, we know that he more than likely gave advice related to bans on torture, federal abortion bans, and giving federal immunity from lawsuits to the gun industry and beyond. In fact, in 2005, President Bush signed into law a law shielding gun manufacturers from all liability related to, I don't want to get this wrong, related to, Jody, do you want to jump in? Related to crimes that happened with.
Sorry, you cut off the gun case?
They just announced they're going to hear it.
Okay, great.
The 2005 law that Bush signed is basically the justices are meeting today to decide whether they're going to hear it.
I'll put it in the chat. I'm also
okay.
in the process of writing you another question in the chat, so I'll add that.
Okay, great. I ad-libbed for a second there. Thanks, Jody. So anyway, the advice that Kavanaugh gave during that really critical time has been shielded from the public. But again, what we do know is concerning. So for example, this is something we do have. This is an email Kavanaugh sent when he worked in the White House. He said, "I'm not sure that all legal scholars refer to Roe as a settled law of the land at the Supreme Court level, since the court can always overrule its precedent. And 3 current justices on the court would do so." So, I mean, honestly, this shows Kavanaugh's complete and utter lack of respect for precedent. And now he's hearing June medical services, and that's really scary. So I'll go back here. I think in terms of personal investigations, there is, again, so much there to uncover. We are all still in awe of Dr. Christine Blasey Ford's bravery from when she testified in front of the Senate Judiciary Committee. And as if the allegations from Dr. Ford and from Deborah Ramirez were not enough, this September, just 2 months ago, a 3rd allegation was revealed by the New York Times. And we learned from the same New York Times investigation that the claims related to sexual misconduct towards Ramirez were never even investigated. So the FBI never even contacted Ramirez or interviewed her, even though she was willing to speak with them, which is totally unacceptable. Based on what we would learn from reading Cavanaugh's records from the White House and from actual complete FBI investigations, it seems pretty likely that we would find that Cavanaugh's own testimony from his confirmation hearing might not all be true. And if that's the case, that's perjury, and that's really serious. So NCJW is calling for this full and complete investigation, and then based on what we learn going from there, but the first step is getting this investigation done. Thankfully, some progress has been made on that front, but a lot more still needs to happen. Back in August, House Judiciary Committee Chairman Jerry Nadler from New York and Hank Johnson from Georgia sent a letter to the National Archives requesting that it complete its review and release records to the committee, to the House Judiciary Committee, related to Kavanaugh's service in the White House from that whole 5.5-year period. And that is a great start, but we haven't seen any records yet. And the House Judiciary Committee is busy with other things related to President Trump, so we really need to keep the pressure on them to do more than one thing at a time. Also in August, Senators Whitehouse and Coons sent a letter to Christopher Wray, who is the FBI director, and they asked him to detail how the FBI handled the investigation of sexual conduct allegations against Kavanaugh. After that was when the New York Times article came out exposing that the FBI didn't even talk to Deborah Ramirez. So this makes this all the more important. We really need to know what the FBI did and didn't do, because again, Kavanaugh will likely be sitting on the Supreme Court, barring any other action, for 40 years. So we need to keep up the pressure, and we'll be sending out a follow-up email after this webinar, and we'll include a link to NCJW's petition, which is urging the House to keep the pressure up on this investigation. So we will now move on to questions, and if you haven't already, you can submit them in the chat box. And you can also just unmute yourself. So feel free to do that. I'll start with the first question, and then I'll pause to see if anyone wants to unmute themselves. All right. So Jody has asked whether the Title VII cases will be decided collectively or individual. And could you extrapolate anything from the marriage equality case to these? Though Justice Kennedy was a key vote in the marriage equality decision, we know it also rested on public opinion and state action affirming marriage equality. Could this also be the case for the Amy Stevens case? Well, Jody, excellent question, as always. The cases don't have to be decided together. It depends how they come out. It's likely that they will be, just because they were heard together and they were consolidated together. But they are different issues. There's two things here: sexual identity, sexual orientation, and gender identity, and they don't have to decide them together. So it depends where they come out. As for anything from the marriage equality case, that is a great question. And I don't know. I haven't read anything that suggests that there would be hints there, except to say that, like that case, one of the reasons that there's so much organizing and action around this case is because of, the court of public opinion. And justices, while they very much make their own decisions, they don't live in a bubble, and they know what's going on around them in the world. And that's why there are rallies, there are protests. And I don't think I gave a hashtag for that, but I will find it. And there are lots of things going on there. At the court, there was a rally, the day of, and we'll keep everyone posted. But it could be the same for that case. Jody, you also asked, actually, Lowell, let me pause here before I keep reading the chat. Is there anyone who just wants to ask a question verbally? If so, you can unmute yourself now. I just don't want to miss anyone. I hear someone. Okay, I'll just keep going. Do you think the House will pursue an inquiry into Cavanaugh's records after the impeachment inquiry? What can be done in the meantime? With so many important cases before the court this session, are there opportunities in which we could see Kavanaugh removed from the court? Sandy Hook, oh, that seems to be a separate comment.
That's for the,
Okay, right. Okay, so yeah, so the House Judiciary Committee has already asked the National Archives for Cavanaugh's records. They haven't done it yet. They haven't produced those records yet. And as you know, what we're asking them to do is keep up the pressure to make sure it doesn't just go by the wayside. In the meantime, we can keep up the pressure on the House to request those records. The Senate's not going to do anything right now with the current makeup of the Senate, but the House certainly can, and we need to remind them that you know, they can walk and chew gum at the same time, and that while some people are still in office for 1 or 2 more years, other people will be sitting on the bench for 40 years. And like you said, time is of the essence because he's hearing these cases now. I will say, interestingly, there was recently a picture released of Justices Kavanaugh and Alito posing with these lovely people. Let me pull it up. Let me see. Can you still see the PowerPoint?
Yeah, we can see the PowerPoint, but we can't see another photo.
Okay, 1 second. There was recently a picture of Justice Kavanaugh and Justice Alito posing with Brian Brown, who is apparently a homophobic activist. He's the president of the National Organization for Marriage and the International Organization for the Family. He posted a picture on Twitter at the end of October with Roman Catholic Cardinal Gerard Mueller and Princess Gloria von something, a conservative Catholic activist from Germany. And Kavanaugh and Alito attended an event featuring those people, sponsored by the IOS a few days earlier. And there is now a push to ask Kavanaugh and Alito to recuse themselves from cases involving LGBTQ issues, because that certainly doesn't send a message of impartiality. So it's doubtful that they will actually recuse themselves, but it's really important to keep an eye on things like this and keep up the public pressure. Jody included a link to the new gun case that they might hear. Yes, Jody, the court still could take cases this term. One of those cases might be the gun case that you put information about up top, above in the chat. So the law I mentioned in 2005 that Justice Kavanaugh likely advised President Bush on is the law that's at the center of this case. So it's called the Protection of Lawful Commerce in Arms Act. And it's blanket protection for gun companies from liability lawsuits, which is what I was trying to get out earlier. So the families of 9 of the victims of the Sandy Hook shooting have banded together and sued Remington, the maker of the rifle that killed the people, well, of the rifle that the murderer in Sandy Hook used to kill the people. And it will be a huge step towards accountability for gun manufacturers if the Supreme Court hears this case and allows it to move forward. Because right now, gun manufacturers are shielded from liability in a very big way. Does anyone else have any questions? Or Jody, do you have any more questions?
I'm happy to cede the questions and return the balance of my time to others. But it is a fascinating topic, and this term is really a blockbuster.
Can I ask a question?
Hi, Ina.
Hi, can I ask just a really out there question? So,
Yeah.
if the president is impeached and the president is removed from office because of, not because of reasons of ineptitude, but because he got there in the wrong way, does anybody talk about the fact that his nominations could be invalid? That the placements of people in positions might be retracted? Does anybody say that people could be removed that he placed in position?
So that's a great question. And it's certainly one that I think should be publicly talked about. The reality is that once they are confirmed to actually remove any of these federal judges, they would have to be impeached. But it's a great question, and there's also a question as to whether, while this is ongoing, should the Senate as a body still be considering, President Trump's nominees? Someone who's going through an impeachment inquiry, does that president really still have the right to appoint judges and have them confirmed to lifetime seats? Now, right now, Mitch McConnell is saying yes, and he has all the power in the Senate, so he's moving forward. But it's a really important question to talk about, because I think people forget that these judges are being confirmed, maybe not these people on this call, because that's why you're here. But a lot of people don't think about it, and it's important to talk about. But like, let's say Trump is impeached, like, the judges don't become invalid, they would have to be impeached themselves. It's a good question. Yes, Jody.
Can I add to Ina's excellent question? NCJW's board of directors was just here, and we were meeting with some folks on the Hill and actually floated that question by some Democratic staffers, and the feedback we got is, there might be some better arguments at the moment. So looking at qualifications and focusing sort of our I think it's a terrific argument, and I would like for us to be using it. The feedback we heard was that focusing on qualifications, they felt at this moment was a better argument.
And the reality is that I think the reason for that is because Mitch McConnell really does hold all the cards, and that while that might be a great argument, he has no shame and would just ignore it.
This is Lisa from Atlanta. I have a quick question. Can you hear me? In follow-up, does the NCJW have any position on the Supreme Court or other courts having term limits or changing the structure of the Supreme Court so that we can avoid something like this in the future, or protect the judiciary from becoming partisan, as it seems it's heading towards, which is very sad, as we all know. So I was just curious if we're taking any position on any of the changes that other groups are talking about.
Yeah, that's such a good question, Lisa. It's something we've been talking about in our office, and that we haven't affirmatively made a decision on yet. There are, consequences that term limits or other Supreme Court reforms can have. So we want to make sure that we really look at everything really carefully, as you know, before we come to a decision one way or the other. But Jody, correct me if I'm wrong, we're not there yet, but I think we will continue to talk about it and hopefully come to some consensus soon on a way that we need to protect and save the Supreme Court. Because you're right, it's become so partisan and it's scary.
It'll be interesting to see if a new administration of the Democrats come in, if that becomes, or if the Senate becomes Democrat in control. It'll be interesting to see what kind of reforms, because it seems like this whole administration, we've seen how things that were just taken for granted as the norm, that a president would never nominate somebody to the judiciary of any level who had no qualifications. And we've seen a lot of them be thrown out because the qualifications were so bad. But I think a variety of issues now, things that were just so accepted as the norm, have been shown that it's not the norm. And since it may require, I wonder what the Democrats, if they do get in any kind of control, what kind of reform they'll take. Especially, I think the judiciary is one that we hope will stay impartial. As a lawyer, I hope so. So it's my 2 cents.
Yeah.
Talk more about it.
Thank you so much. Thank you. Anyone else? I'll just share one question I got in advance. And I know that people will be watching this recording, so I wanted to be sure to answer it. I was asked the process for impeaching a Supreme Court justice. And the answer is that it's the same for impeaching the president. So the House of Representatives would vote on whether to impeach the justice in question. And if impeached, there would then be a Senate trial for removal. The House needs only a simple majority to impeach a Supreme Court justice, or any other federal judge for that matter. To convict and actually then remove the justice or judge requires a 2/3 majority in the Senate. And impeachment and removal of federal judges is extremely rare, but it has happened. The House of Representatives has impeached 15 judges, 15, since 1803. 8 of those were followed by convictions in the Senate, meaning the judges were then actually removed from the bench. Samuel Chase was a Supreme Court justice who was impeached in 1804, but he was acquitted by the Senate in 1805. So he didn't actually leave the bench. Any other questions? Well, Lindsay has a short wrap up, I believe.
Yeah, thank you so much,
All
Caroline.
right, Lindsay.
Hi, everyone. That's all we have time for today. Thank you so much for tuning in and for your insightful questions and conversation. And thank you, Caroline, for all the information you shared with us. So at the start of the webinar, I asked you all to keep those lower court judges in mind. I mentioned that most cases make it to the district or maybe circuit courts, but that very few actually make it to the Supreme Court. So right now, there are several pending nominees for federal district and circuit courts that NCJW is gravely concerned about. At the forefront is Stephen Menashi, who's been nominated to serve on the Court of Appeals for the Second Circuit. Actually, I want to give you those states. Where's my map? I turn my head. So that's New York, Vermont, Connecticut. Am I missing anyone, Caroline? Maybe Rhode Island? Anyways, so just yesterday, the Senate Judiciary Committee voted 12-10 along a party line to advance his nomination to the full Senate. And just hours later, Senate Majority Leader Mitch McConnell filed cloture on the nomination, which basically means it's set up a timeline for a full vote next week on this nominee. So among other things, Menashi is an uber-conservative ideological lawyer who most recently worked with Stephen Miller in the White House, advancing some of the nation's most draconian immigration policies. He also worked with Betsy DeVos at the Department of Education and has a history of incredibly offensive writings. He is one Senate vote away from serving for the rest of his life in a seat once held by Thurgood Marshall on a court just below the Supreme Court. This is serious, and all of our senators need to hear from us. Please keep an eye out for a follow-up email from NCJW. It'll contain more information about Menashe, as well as other nominees we're concerned about, and how to contact your senators to voice your concerns. The follow-up email will also contain several other resources, including NCJW's What's at Stake in the 2019-2020 Supreme Court term, which has a lot of what we discussed today and additional information about several other cases. We'll include a link to the Kavanaugh petition that Caroline mentioned and several other resources in case you really want to dig deeper into these fascinating cases. Last but not least, we'll include a survey, so please take a minute to fill it out. Your feedback informs our future programming, and we want to hear from you. So thank you again so much, and have a wonderful day.